Okay, Your Honors. I just want to make some preliminary statements. In response to your invitation, I am here to answer your questions. I know that there are many resource speakers scheduled for today, and so to abbreviate the proceedings, I emailed a copy of my sworn affidavit last Wednesday, and I also emailed this morning the timeline delineating the sequence of events that transpired in relation to this case. I also would like to manifest that I am not appearing as a witness for the complainant, Attorney Gadon. I do not personally know Attorney Gadon. I just met him this morning. Attorney Gadon mistakenly thought that I was the assigned member with respect to the Maote case, probably because I circulated a memorandum to the members of the NBank. All right. Now, I am not the case was not raffled to me because, first of all, the results of the raffle is confidential. Nobody knows the results of the raffle. Secondly, you come to know that you are the case is raffled to you if you are notified by the raffle committee, and the rolio is forwarded to your office. All right. Now, another manifestation I'd like to make is that Secretary Aguirre is a personal friend of mine for more than 40 years. We've been classmates in college as well as in law schools, and we occasionally or oftentimes meet each other on social events. Now, the reason I circulated a memorandum to the members of the NBank was because my attention was called that despite the letter request of Secretary Aguirre, the request was not fully granted by the NBank, and Secretary Aguirre filed a letter of reconsideration, which he addressed to the Chief Justice. All right. And lastly, I'd like to manifest that the Supreme Court is a collegial, it is a consultative, deliberative, participatory body. The Chief Justice is not the Supreme Court. In other words, unlike the chief of a tribe in a community, the chief of a conglomerate, the chief of a group of companies, the Chief Justice cannot overrule, supersede, or cancel the decision of the NBank. That is the reason why in two recent important cases, the Lima petition and the martial law petitions, the Chief Justice voted with the minority. And therefore, since the majority has spoken, the Chief Justice has no power or authority to overrule the decision of the majority. And finally, the Chief Justice does not have absolute powers, because even the matter of purchase of vehicles, even the matter of going on official leave has to be submitted to the NBank. Now, with the permission, Your Honors, I'd like to go over the salient matters in my sworn statement. The administrative matter is 17-06-2. It pertains to the letter dated May 29 of Secretary Aguirre, addressed to the Chief Justice, asking the Supreme Court to designate special courts outside of Mindanao to hear criminal cases arising from the Maote Group takeover of Marawi City in order to ensure the safety of all who would take part in the judicial proceedings, including judges, court personnel, prosecutors, against possible threats and acts of violence from said group. Then I came to know later, I have not yet circulated the memorandum, I came to know later that on May 31, 2017, The court administrator, Midas Marquez, wrote to the Chief Justice supporting the request of Secretary Aguirre. The court administrator recommended that two regional trial courts of Taguig City be designated as special courts to hear criminal cases arising from the Marawi siege. Court Administrator Marquez explained that most of the rebellion and terrorism cases were being heard by the RTCs of Taguig City because of their proximity to the Special Intensive Care Area, or SICA, of the Bureau of Jail Management and Penology, located in the same city. He stressed that only the SICA was equipped to capably detain high-risk inmates. I borrowed the rolio of the case from the Office of the Chief Justice, and I assumed that it was raffled to her because she was the one who reported to the NBank this particular matter. I was surprised that the May 29, 2017 letter of Secretary Aguirre was not attached to the rolio of the case, but it was stamped received by the Office of the Chief Justice on the same day, May 29, 2017. Likewise, the May 31, 2017 memo of the court administrator was not attached in the rolio of the case, but was stamped received on the same day, May 31, 2017. Okay. Now, the May 29, 2017 letter request of Secretary Aguirre was then included as one of the items in the agenda of the court during the NBank on June 6, 2017, and it was docketed as AM number 17-0602. It was set as item 53 of the supplemental agenda for administrative matters. During the June 6, 2017 NBank session, the court discussed items similarly included in the court's agenda, but the letter of Secretary Aguirre, dated May 29, 2017, was not taken up. Around noon of the same day, however, after the NBank session ended, I was in my office. I was recently appointed in March 2017, and the office in the Supreme Court was not yet ready, so I was still holding office nearby at my old office at the Court of Appeals, which is about 10 minutes walk. Around noon of the same day, and this is included in my affidavit, I received a phone call from the Chief Justice, and it was then that I came to know from the Chief Justice that she had discussed Secretary Aguirre's request with the other members of the court during lunch following the NBank session. She told me, "You were not here, but we decided that the case be heard in Cagayan de Oro." So with that manifestation of the Chief Justice, she manifested to me that the majority of the NBank agreed to hold the trial of cases in Cagayan de Oro. I said, all right, if that is the wish of the majority, I will abide by it. And there was a resolution finally dated June 6 was issued by the court reflecting the decision. Your Honors, lunch is held on the adjoining room to the NBank session, which is an executive session, where the doors are bolted, all right? The lunch is attended by the members of the court, but not all members are present. Now, I do not know how many members were present during lunch, but there is a distinct difference between discussing something important during the NBank session, where you have the docket folders, you have the materials with you, and holding a caucus on an important matter where in front of you are plates, forks, and food, all right. Anyway, The manifestation of the lawyers of the Chief Justice is that it was submitted to the full court. The discussion was not. The resolution of June 6, 2017 was apparently signed by us, and so in that manner it was submitted to the full court. Now again, what I'm saying is that in an en banc session, if the Chief Justice is the member in charge, it is incumbent upon her to submit a recommended action. All right. I was listening to previous hearing of this honorable committee, and there was confusion as to the meaning of recommendation. It is a recommended action, not to the Chief Justice, Your Honors. It is a recommended action to the en banc. And when a recommended action is submitted by the ponente or the member in charge, he or she is supposed to justify the recommended action. And if he or she is not ready, then he can recommend to call the matter again on a later date. All right. I submitted a copy of the June 6 resolution. On June 13, 2017, Secretary Aguirre sent a letter to the Chief Justice seeking reconsideration of the Supreme Court June 6, 2017 resolution, reiterating that the RTC of Taguig City, instead of the RTC of CDO, be designated as the court to try and decide all cases and incidents arising from the Marawi siege, and that the SICA be designated as the detention facility for apprehended members of the Maote group, since it houses high-profile and dangerous individuals. Secretary Aguirre informed the court that he had conducted an ocular inspection of Camp Evangelista and found that it lacked adequate detention facilities to accommodate apprehended members of the Maote group. The Secretary also noted that the Armed Forces of the Philippines did not have sufficient training in proper jail management nor funds for the detainees' provisions. He further noted that the modest office of the CDO City Tourism Hall, to which the courts temporarily transferred after the CDO Hall of Justice was gutted by fire in 2015, could not accommodate the detainees to be arraigned or undergoing preliminary investigation on trial, and was not secure enough for high-profile and extremely dangerous individuals. On June 14, 2017, Court Administrator Midas Marquez issued a report and recommendation in compliance with the Court's June 6, 2017 directive to coordinate with the Commanding General of the 4th Infantry Division in Camp Evangelista for appropriate and secure detention facilities. The Court Administrator reported that the Executive Justice of the Court of Appeals in Mindanao expressed apprehension in holding the trial of Maote cases in CDO, noting that the CDO RTCs did not have adequate space to handle the cases, and that CDO, which has had its share of threats of bombings and other atrocities in the past, was not at a safe distance from the axis of rebellion. He further informed the Chief Justice that the RTC judges of Cagayan de Oro City, expressing safety concerns, hope that the Supreme Court would reconsider its June 6, 2017 resolution. And then the Court Administrator likewise informed the Chief Justice of the following: a resolution issued on June 8, 2017 by the Integrated Bar of the Philippines, CDO Misamis Oriental Chapter, stating its strong objection to the transfer of the trial of Maote cases to CDO courts. Secondly, the joint resolution against the holding of the Maote trial in CDO, which the Misamis Oriental Filipino Chinese Chamber of Commerce, the Cagayan de Oro Filipino Chinese Chamber, the Philippine Chamber of Commerce and Industry, Northern Mindanao, and the Cagayan de Oro Chamber of Industries were preparing. And Court Administrator Midas Marquez also submitted the board resolution of the Cagayan de Oro Chamber of Commerce and the business communities there, composed of 400 industry key players, large, small, and medium enterprises, and micro businesses, condemning plans to hear the Maute cases in CDO and citing huge losses upon the siege of Marawi, which would reportedly increase should the Maute trials take place in their city. Administrator Marquez also submitted the June 13, 2017 letter from the CDO City Council's majority floor leader manifesting the objection of the Council's majority to the Court's June 6, 2017 resolution, and noting that without a Hall of Justice, the CDO RTCs were temporarily hearing cases in any available conference rooms or offices in the City Hall compound, with so many ingresses and egresses which could cause a security nightmare. Pending the Court's resolution of Justice Aguirre's request for reconsideration of the June 6, 2017 resolution, and considering that cases arising from the Marawi siege were already being filed, the Court Administrator recommended the designation of particular branches of CDO RTCs to hear such cases until further orders from the Supreme Court, the presiding judges thereof, to be accorded sufficient security detail. It is unfortunate that the Chief Justice did not trust the Court Administrator of the Supreme Court. He did not heed the recommendation of the Court Administrator. He did not even inform us of such recommendation. And even during lunch, he did not even summon the Court Administrator to inform us so that we can have a complete analysis, evaluation of the situation so that we can make an informed decision. On June 14, 2017, my office circulated a memorandum of even date among the other members of the Court and Bank, informing them of my vote to grant Secretary Aguirre's request to transfer the venue of the Maute cases to the RTC of Quezon City due to security concerns which may adversely affect the inquiry into and adjudication of the cases. The Court and Bank met on the same day for an executive session and for the continuation of oral arguments in connection with the petitions assailing the proclamation of martial law in Mindanao following the Marawi siege. The venue of criminal cases arising from the siege was not discussed. Now, I read somewhere that the lawyers of the Chief Justice made a manifestation that this was not immediately, the request was not immediately granted by the NBank because the NBank was busy with the oral arguments on the martial law petitions. That is correct. But there is a certain degree of mental dishonesty. The oral arguments on the martial law petitions precisely pertain to the Maute uprising, armed uprising in Marawi City. In a follow-up letter dated June 14, 2017, received by the Office of the Chief Justice on even date, Secretary Aguirre asked for the immediate approval of his request for reconsideration of the Court's June 6, 2017 resolutions. Secretary Aguirre informed the Court that at least 3 prosecutors already declined their inclusion in the panel of prosecutors assigned to the Maute cases because of fear for their safety. The Secretary also submitted to the Court a copy of the resolution issued on June 8, 2017 by the Misamis Oriental chapter of the IBP strongly opposing the transfer of the Maute cases to the CDO courts. He wrote that taking a proactive stance could allay the fears of everyone who would be involved in the prosecution and trial of said cases. And then on June 19, 2017, these are letters which we came to know only after the fact. These letters were never submitted by the Chief Justice to the NBank. Secretary Aguirre sent another letter addressed to the Chief Justice reiterating his request that the Maute cases be heard before the RTCs of Quezon City instead of the RTCs of CDO. He also asked the Court to allow the cases to be heard at an appropriate venue inside the SICA to ensure greater security of the detainees. Requesting an immediate positive response, Secretary Aguirre informed the Chief Justice of the imperative need to free AFP personnel in Camp Evangelista, CDO, from the additional task of safeguarding apprehended Maote group members to enable them to focus on the ongoing military operations to liberate Marawi City. I was listening to the hearing during the previous hearing, and somebody asked that nothing happened in the interim. Well, if the Chief Justice is psychic and she has a foresight that nothing will happen in the future, then we should be thankful to her. But something did happen. The Marawi uprising expanded, and there were Maote followers arrested in CDO. I remember the mother and the brother of the Maote were arrested in CDO. So many things happened. And I think it is imperative that these precautions, if these were heeded, could have averted what could be more serious. It would have put Cagayan de Oro out of harm's way and also part of Mindanao. Now, the pending incident, Secretary Aguirre's request for reconsideration under his letters June 13 and 14 was scheduled for the Supreme Court en banc deliberation on June 20, 2017. Unfortunately, the recommended action of the Chief Justice, as the justice assigned to the matter, was to call it again after 1 week, or on June 27, 2017. There's nothing wrong with that. Members of the court, if they're not ready, they can ask that that the matter be called again on another date. Now, the pending incident was subsequently included in the agenda of the en banc for June 27, the date requested by the Chief Justice. Now, during the June 27, 2000 session, the Chief Justice referred the matter to the en banc in consulta, meaning that the issue would be discussed with the other members of the court en banc. Again, I do not remember any documents that were submitted to us to enable the members of the bank to have a complete understanding of the situation. Now, after the June 27, 2017 en banc session, the court issued a resolution granting Secretary Aguirre's request and designating the RTC of Taguig City instead of the RTC of CDO to act on all prosecutions and incidents arising from the siege in Marawi. However, the court noted the risk of detaining suspected terrorists in congested urban areas. Hence, it merely designated the SICA in Camp Bagong Diwa as a temporary detention facility and ordered the BJMP to expedite the relocation of suspects involved in the Marawi siege to a detention facility outside of the congested urban areas, such as Fort Santo Domingo in Santa Rosa, Laguna. Was the request of Secretary Aguirre fully granted? No. On July 3, 2017, Secretary Aguirre wrote to the Chief Justice, reiterating the request under his letters dated June 13, 14, and 19, and the Secretary submitted a copy of a resolution of the Sangguniang Panlalawigan of Misamis Oriental expressing their strong opposition to the trial of Maote cases and the detention of apprehended members of the Maote group in CDO, and urging the Supreme Court to allow the detention, prosecution, and trial of the apprehended individuals outside of CDO in the province of Misamis Oriental. On August 1, the Office of the Court Administrator submitted a memorandum to the Office of the Chief Justice recommending the designation of branches 70 and 266 of the RTC of Taguig City as special courts that would try, hear, and decide cases arising from the Maote takeover of Marawi City. Finally, on August 2nd, 2017, the Office of the Court Administrator sent another memorandum dated August 1 to the Office of the Chief Justice recommending that branches 74 and 116 of the MTC of Taguig City be designated as special courts. Finally, on August 8, 2017, the Supreme Court en banc issued two resolutions adopting the July 31 and the August 1, 2017 recommendations of the Office of the Court Administrators. 2 months lapse, and it was only on August 8 that the NBank finally acted on the matter to the full satisfaction of the Secretary of Justice. Now, my question is, were the conditions existing on May 29, when Secretary Aguirre made a request to transfer the venue, the same as the conditions existing on August 8, when the NBank finally relented to the request? So that's the question that the Chief Justice should answer. This matter, we cherish, we need, it is imperative, it is important for the NBank to consider matters of urgency. And you can only consider these matters of urgency if the NBank is given full information, immediate information, complete information. I'm trying to decipher the reason why, I would not use the word delay. I'm trying to decipher why the Chief Justice did not act on it promptly, being the member in charge. I was not the member in charge, but I acted more promptly by circulating a memorandum to the NBank and trying to force a vote, because you can only force a vote if there is complete information and there is consultation and deliberation. Now, I may be mistaken, but after the decision in the martial law petitions, the Chief Justice voted in the minority. It was a vote of 11, majority 3. The Chief Justice, the Honorable Justice Carpio and the Honorable Justice Caguiwa, who sustained the imposition of martial law, but only in Marawi and certain parts of Mindanao, but not the entire Mindanao. And of course, there was the dissent of Justice Leonen, who thought that it was a peace and order situation that could be quelled by the armed forces without need of imposing martial law. I am of the thought that probably the reason why the Chief Justice did not act on it, because she was not satisfied that the danger, the risk, and the harm that may befall the non-transfer of the Maote prisoners to Metro Manila would be that large, would be that extensive. So it could be that. But the point is, regardless of the thoughts, regardless of the sentiments, regardless of the feelings of the Chief Justice, she should have taken the initiative of bringing it to the attention of the NBank, because after all, it is the NBank that will decide for the court.